All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Welcome and good morning. We are here for oral argument in case number CV23-0028, DMS Companies versus Hernandez. Each side has 20 minutes for argument. The appellant may reserve time for rebuttal. I just ask that you do that yourself with the clock that's on the podium. Our proceedings are being audio and video recorded, so if you can introduce yourself and your client, it would be appreciated. We read the briefs, discussed the case in conference this morning, and are familiar with the issues raised, so please keep that in mind when making your arguments, and with that, you may proceed, counsel.
Good morning, Your Honor. Jimmy Purcell, Quarles and Brady, representing the appellants. There's a core issue in this matter that I think the court could benefit from stripping away a lot of what I see as the chaos in the case citations. The issue here is, can DMS be compelled to comply with the alternative dispute resolution procedure that's clear and unambiguous in the contract? What parties have argued...
Isn't the question whether there is such a procedure to begin with?
I don't believe so, Your Honor. The language of the contract is clear. It sets out a procedure in the event that there is a disagreement as to the working capital statement. And we'll talk in a minute about what working capital means and why that is intrinsic in virtually every claim that's been brought in this complaint. That procedure involves the sellers, my clients, presenting their version of the working capital statement. In the event there's a disagreement by DMS as to whether or not there's an accuracy there, then DMS, there's a period where they try to work it out, and then there's a deadline by which they're supposed to resolve it. And if they don't, the parties shall submit that. Each will submit their own to Grant Thornton, third-party neutral adjudicator that was negotiated and agreed to by the parties. Grant Thornton has the ability to ask follow-up questions, look at documents, get whatever information that they feel is necessary, and then under the terms of the agreement, shall determine the final working capital statement. That's clear and unambiguous in the language, and it's...
Right, and then what that statement is a piece of paper that lists current assets and current liabilities, and I guess in a vacuum, what benefit does that have? I mean, it just seems very different to me, to put it differently, than an arbitration award. You then take that statement and you compare it to a prior statement that occurred or was created at closing, and then one side pays the other some additional funds.
Correct. It's akin to a declaratory judgment, in essence. It's a declaration by the third-party decision maker as to which of these statements is correct, and if neither is correct, they come up with their own version. And that is no different than issues that are arbitrated all the time as the case law sets out.
So then so that's an arbitration provision as to all claims that might arise? Is that how we're to understand it?
No. What our motion to compel was to compel DMS to comply with the plain language of the agreement and submit the working capital dispute to Grant Thornton for resolution. And I would disagree, Your Honor, that the working capital is just an assets and liabilities list. It's defined. I've got the definition in the briefing. It includes AR, it includes inventory. At a broad level, maybe it's assets and liabilities. But
sure, yeah, it's more detailed than that.
A lot of things that are being complained about in the complaint get resolved. We misstated our AR. We misstated our inventory. Those factual disputes get resolved by Grant Thornton resolving what the appropriate working capital statement is, and it becomes final. And then what we're litigating about are the additional claims, the additional issues. We'll have a decision on some of the breach of contract claims. There's an actual breach of contract claim in the complaint, the amended complaint, that accuses my client of submitting a working capital statement that didn't comply with GAAP. Well, that claim would be resolved by this issue. But it's not all claims, Your Honor.
Let me ask you a question. Couldn't you move in this lawsuit or in a separate matter to compel the parties to go to Grant Thornton and determine the prevailing working capital statements?
I believe that's what I did at the trial court level, Your Honor.
No, I think you could seek specific performance, for example.
Right.
I think that is correct.
Okay.
But the issue with that is that it deprives my clients of the resolution of this issue on the front end.
Well, then I was going to say, then you have a piece of paper, and why isn't that evidence in this lawsuit? Seems to me there's a difference between a binding final resolution and an agreed-upon third-party auditor who can compile great evidence, maybe for your client, but it's only that. It's just that. It's evidence in the lawsuit about these claims that involve the statement.
Well, it will be evidence, but it's also binding and conclusive, Your Honor. By definition, in the asset purchase agreement, the purchase price adjustment is done based upon the final working capital statement. The final working capital statement is defined in the agreement as the working capital statement agreed to between the parties, and if there's no agreement, the working capital statement determined by Grant Thornton.
Right, but again, why isn't that either great evidence for you or evidence in the lawsuit? I mean, it just seems to me that there's a difference between a document that might have some sort of binding effect in the course of a lawsuit and a complete bar to the third branch of government courts.
Well, Your Honor, that's exactly what an arbitration is.
Well, but you're the one calling it an arbitration.
Correct.
What I'm saying is, let's say you're both required to do it, there's going to be a statement, and it could be evidence in a lawsuit. Why isn't that what it is?
Because Arizona courts have never recognized the distinction that the other side is asking this court to recognize. And I think I started my presentation with, I want to try to clear up some of the chaos and the confusion. And what I'd like to do is walk through one of the cases that's at issue here. One of the ones cited by the other side is the Penton case. And there's a body of case law that distinguishes between expert determinations and arbitrations. And that's what's relied on by the other side. Is this an expert determination or is it an arbitration provision? And there are cases from other jurisdictions that go through that and analyze what are the touchstones of each of those. And I would assert, Your Honor, that in this case it doesn't make any difference, because when those cases are decided, they're decided in the context of some other issue that the court is addressing. For example, in Penton, virtually identical situation as to what we have here, in that there was it's a merger agreement, I think, in Penton, but there was additional things that needed to be calculated. There was an agreement that would go to an accounting firm, and there was a dispute as to whether or not the accounting firm could consider extrinsic evidence. That's the core issue. That's what's being decided in Penton. And in Penton, the court looked at it and said the answer to this depends on whether or not it's a expert determination or it's arbitration. And it was the old law school difference between substantive arbitrability and procedural arbitrability. Who has the jurisdiction to decide these issues? Excuse me. And what the Chancery Court in Delaware decided was there is a long history of distinguishing between those two under under Delaware law. And if it is an expert determination, then issues of procedural arbitrability nevertheless reside with the court. If it's an arbitration clause, then the party deciding, in this case the accounting firm, decides procedural arbitrability issues. Ultimately, the court decided that it was an expert determination, and therefore it was decided by the court whether or not there could be extrinsic evidence considered. The court decided no extrinsic evidence based on the language of the contract, but at the end of the day, the court required them to submit it to the accounting firm for determination, and that determination was final.
Through a motion to compel arbitration or through some other procedural mechanism?
In that instance, it was litigation by both sides with declaratory judgment actions on each side.
Right.
But, Your Honor, in that decision, there are footnotes 41, 42, and 43 that I think are very instructive, along with the discussion around those footnotes. And what the court does in the analysis is talk about the history of this idea of an expert determination. What the court says, this is Delaware court, is that at common law, there was a distinction between an expert determination and an arbitration. This is 1910 U.S. Supreme Court. The outcome of that case involved whether or not the losing party in that proceeding could challenge it because they didn't get a fair hearing. Supreme Court said it's not an arbitration, it's an expert determination, and you're not entitled to a fair hearing, but you agreed to it nevertheless so that it is binding on you. You're required to do it, and it's binding. In 1925, the Federal Arbitration Act is passed, and you end up with a blurring of those lines. Ultimately, what the Delaware court pointed out, and this again is the discussion around 41 through 43 footnotes, unfortunately, subsequent developments blurred once clear doctrine. The passage of the FAA in 1925, the articulation of a strong federal policy in favor of arbitration, and the adoption of comparable arbitration acts and policies at the state level led to rules that favored arbitration. As litigants sought to escape from the court into an arbitral forum, the judges sought subconsciously to lighten heavy dockets. Arbitrable principles seeped into and in some jurisdictions swamped the law governing expert determinations. It notes that one national survey posits that only 24 states continue to recognize a distinction between experts and arbitrators. In 22 states, the distinction has been lost, and in 4 the matter has either been resolved ambiguously or not at all. The footnote cites to a law journal article that's cited in the footnote and is available on Westlaw, has a chart, and that's what the court's citing to, which states view expert determinations and arbitration agreements as the same. Arizona is listed as one of the 22 for which there is no difference. And in that case, it's actually dealing with appraisal provisions, but the Delaware court treated those as essentially expert determinations. Appraisal equal arbitration. That's what the law journal article that this case cited concludes. And that's entirely consistent with Arizona law on this subject.
Well, Arizona law, isn't it, you need a meeting of the minds? It's an agreement to arbitrate. So let's talk about Arizona law.
Mm-hmm.
Meeting of the minds, we have this sentence, third-party auditors shall determine the prevailing working capital statements. And what you're saying is that objectively, that is an arbitration provision that both sides agreed upon and there was mutual assent.
Clearly, yes, Your Honor.
Well, clearly, putting the word clearly aside, why isn't, I'm going to ask you again, why isn't my version, which is this still has to be done, the parties still have to do this, Grant Thornton still needs to determine this, but it can be, Exhibit A in the lawsuit. Doesn't that sort of still recognize the words of the document and provide an avenue for relief or procedural due process?
I would assert, Your Honor, that outcome is inconsistent with Arizona law, and I'll cite the cases that I'm referring to. They're in the briefing, but it's Hurt v. Hervey, which I'm sure Your Honors have looked at.
Well, Arizona law, I think we both agreed, is a meeting of the minds.
It is a meeting of the minds.
You have to agree to arbitrate. We have this language.
Well, the question, Your Honor, I think is a little bit more nuanced than that. Because if that's Your Honor's test, then we're imposing a magic words test. We've got to use the word arbitrate, and if we could agree to get 3 neutral parties, we're all going to present evidence, and they're going to render a decision that's binding.
Binding, does the word binding appear?
Uses the word final. Shall determine the final working capital statement.
Isn't it shall determine the prevailing working capital statement?
And then in the definition section, in the same 2.06, final working capital statement is defined as that determined by.
Right. So you're saying binding is a synonym for final?
If the parties agree that this is the way the resolution of an issue is going to occur, then it would be binding on the parties. But if I may, Your Honor, if you look at...
So my understanding is Grant Thornton creates a statement. It's a working capital statement. The definition of an arbitrator under Arizona law is someone who issues an award.
Correct.
An award to me is something you can take and enforce against someone else, akin to a judgment. How is the statement that Grant Thornton creates akin to a judgment that can be enforced against anyone else? I guess to Judge Weinsweg's point, maybe great evidence for you in the lawsuit, but I'm not, how is it an award?
Your Honor, than a declaratory judgment. And the statutes are clear that the judgment, even if it's something a court couldn't award, even if it's something other than monetary damages, an award can be pretty much anything that's a decision of the arbitrator, and it's no different than going to court, and this is ARS 12-3021, it's no different than going to court and getting a declaratory judgment. It becomes binding. It doesn't award monetary damages. That's just the term of art. This particular declaration, determination by Grant Thornton, would be the equivalent of an award because it resolves this dispute in the same way that a declaratory judgment resolves a dispute in a court of law. The one thing I'd like to point out before I reserve a little bit of my time, continuing on the Arizona case law, if you look at the Meineke case, which is, there's Hurt v. Hervey, then there's Meineke. Both of those cases basically say that an appraisal provision, which is considered an expert determination in courts that follow that dichotomy, is enforceable the same way an arbitration provision would be enforced. And in fact, in Meineke, it came up in the context of a motion to compel arbitration. And the trial court denied that, finding a waiver. It went up to the Court of Appeals, and the Court of Appeals agreed that there had been a waiver of the provision, but never criticized the idea that it could be considered arbitration for purposes of compelling arbitration. And in fact, the one dissenting judge who decided there was no, as Judge Voss decided there was no waiver, would have remanded and compelled compliance with the procedure. All of the case law, including in 2008 Chapman v. the Western decision, treat appraisals, which even though there may not be all of the things attributable to arbitration grafted onto appraisals, nevertheless, they're still binding in that sense. And the law is clear on that even as recently as 2008. The issue in Chapman was not whether or not it was binding, it was which award was binding, which appraisal was binding, and whether or not the losing party could then try to argue that when the appraiser issued a first appraisal, that it was the last word. The appraiser couldn't then revise it because an arbitrator can't revise an award except in certain circumstances. What the Court of Appeals said is, we may not do everything for arbitrations or for appraisals that you do for arbitrations, but at the end of the day, they're just as binding. And that's what we're looking at. And Your Honor, that's the answer to your question. Under Arizona law, these things that are expert determinations are just as binding as an arbitration award.
Do you have the cite of Meineke? Because I'm looking at your opening brief and I don't see it even cited. What's the citation?
I know it's addressed by the other side.
Oh, okay, that's fine. I'll look at the other side. Okay, I got it.
Okay. Thank you. And I'll reserve the remainder of my time.
Good morning, Your Honors. My name is David Fitzgerald. I represent the plaintiff appellee, DMS Companies, Inc., the president of which, Deborah Stephen, is here with me today in the back. May it please the court. The court should affirm the order denying seller parties' motion to compel arbitration. Here, there is no agreement to arbitrate. Arizona law requires specificity and clarity. Under Arizona law, the fundamental prerequisite to arbitration is the existence of an actual agreement to arbitrate. That's the Escareno case. Under our state's law, a party is not bound to arbitrate disputes it has not specifically agreed to arbitrate. That's the Duenas case.
Do you agree or disagree that the statement that Grant Thornton would create is binding on the parties?
I disagree, Your Honor. If you mean binding on the court like an arbitration, I disagree. There's no...
Well, it's binding on the parties to the extent it then flows into the other provisions in 2.06 in determining how much one or the other then owes for purposes of working capital, right?
When you have an expert determination versus an arbitration, one of the things that the party can do with the expert determination is to see if the expert did the correct determination. Here, my clients intended for the arbitrator to resolve issues over the final working capital statement in accordance with GAAP. When we got to trying to work out an engagement letter, the third-party auditor didn't want to refer to GAAP in the engagement letter. When we cited in the engagement letter process with the third-party auditor, Section 1.02, which requires all calculations and determinations under the agreement to conform with GAAP, the third-party arbitrator said it would be guided by the APA, but not that it would be bound by that, and it wouldn't make any reference to Section 1.02, which was fundamental to my client's agreement to have anything to do with Grant Thornton as the third-party auditor.
So I guess, are you saying that Grant Thornton can produce the statement and that your client or even Mr. Purcell's client could second-guess those numbers at some point later?
That's correct. And going to Your Honor's point, if your version is it's evidence, perhaps both parties will agree, and then the deal's done, and the working capital, any working capital calculation issue is agreed satisfactorily.
Mason, how is your position consistent with the definition of working capital statement in the asset purchase agreement, which says the working capital statement is the statement created by Grant Thornton if the parties don't otherwise agree? Because
the rule of contract construction is you have to consider the agreement as a whole. And if the third-party auditor will not agree to perform its calculations under GAAP, if they will not agree to Section 1.02, then if my client thereafter disagrees with the third-party auditor determination, then my client should be able to dispute that calculation.
But doesn't the revised Uniform Arbitration Act have provisions that deal with how parties select an arbitrator? And maybe that is a reason why this is arbitration. If Grant Thornton isn't willing to do its job, maybe the revised Uniform Arbitration Act would suggest procedures for choosing someone else.
No one made the gap filler argument I think that you're sort of positing, but if there's nothing indicating here that this is an arbitration. I know that the council has made the point that you don't need magic words. We cited a case in a supplemental brief. We did it last week. I'm not sure if you had the opportunity to see it. The SAP case. It agrees. A magic word's not necessary. However, it is indicia of an agreement to arbitrate, and the lack of such magic words is therefore indicia of an agreement not to arbitrate, i.e. an expert determination. So the SAP case really addresses, although it doesn't by name address, I think, the FitTech case cited by the other side, it really does it shows that the Penton case is not an outlier under Delaware law. It's now a Third Circuit case deciding many issues that are relevant here.
So let's say we end up saying this is not an arbitration provision, and Grant Thornton still won't agree to the terms that your client would like it to. Where are the parties then at that point?
They're with our lawsuit because we're not asking for a determination in the lawsuit over the working capital calculation. That's not my client's claim.
But doesn't a few of your claims are certainly are colored by whatever would be in that document? Wouldn't you concede? And I can read them out to you if you'd like.
For example, if the other side had misstated its accounts payable or misrepresented intentionally or unintentionally
Liabilities.
its accounts payable, one of the liabilities, it may have a bearing on the working capital. I mean, that would have a bearing on the working capital calculation. I mean, that it would.
But Grant Thornton's not going to say, for example, accounts receivable are $50,000, but I think one side or the other committed fraud.
That's precisely true, Your Honor.
Right.
They're not going to say that. And they're not even going to consider the law or any statutes in making their determination. Another reason that the court shouldn't conclude that this is an arbitration agreement. How can you arbitrate a claim if you don't consider the law?
Counsel, but again, would you concede that this document, the capital working statement, is a data point, maybe a very significant data point in those claims? Fraud. Right, it doesn't say there's been fraud, but it provides numbers upon which a fact finder could determine fraud.
I mean, your damages, at least, are going to be based on what the statement says versus what it would have said if fraud was not committed, correct?
I used to be an auditor. I'm not trying to express an opinion on any auditing thing.
I'm not asking you.
I don't think Grant Thornton will render an opinion if fraud is at issue. They're going to say we can't determine what the financial statements are because there's been fraud committed, but we're not going to consider the law to determine whether this rises to the level of fraud. So it's somewhat circular. There is accounts receivable, accounts payable. If there are misrepresentations as to those matters, some of that may be, might fit within the definition of working capital.
And I don't even want to call it misrepresentations or anything, but if they do their job, they're going to compile information on a working capital statement, and it sounds like you're not going to, that wouldn't be a piece of evidence in the lawsuit or relevant? Would you concede that?
I think it could certainly be evidence if they went down, if we went to that road, if we did that. But if the statement they compile is not rendered under GAAP, is not rendered under Section 1.02, but rather is rendered under the theory that we like seller parties' statement better than buyers or vice versa, the counsel said, well, they can come up with their own statement. I don't think that's what that agreement says.
I didn't say it was persuasive, it was the game changer, but it seems to me that this is maybe the letter A or B in the alphabet that would be resolved in the course of the lawsuit, a critical piece of evidence?
So somebody, one side or the other, may really like the result and may wish to use, from Grant Thornton, and may wish to use it as evidence if we proceed on that basis, but that's not the same thing as moving to compel arbitration, which has specific review standards that an expert determination does not have. The Chapman case, there was much discussion about Meineke and another appraisal case. Well, I'm not claiming this is an appraisal, more like an expert determination, more like the SAP case and the Penton case. But it's the ramifications of calling it an arbitration.
How is this case different than Meineke?
Well, the case Chapman says that all arbitration procedures are not engrafted onto appraisal. So first of all, I think Meineke's appraisal, it's not the expert determination is not limited to appraisal. The Penton and SAP case make clear that it can be auditor determinations, which would be our case. This is an auditor determination. It's not an appraisal. We're not looking for fair market value from a real estate type person. This is an auditor.
Let's say, I'm reading right from Meineke, and let's say the clause says this, and it did. The amount well, they'll submit an agreement to us, the amount agreed upon will be the amount of the loss. Is that different from the words? Is there something, I mean, so again, looking to that, is there anything in your document that says the amount agreed upon will be the amount of the loss? The appraisers, and I'm just looking at that provision, the clause in Meineke.
Yes, Your Honor. If I might,
I guess-
just bear with you for a minute. Can you tell me where you're looking at?
Let's just say it says that.
I just want to see the surrounding language, Your Honor. That's all I was.
Okay, page 578 to 579.
Okay.
The appraisers will separately set the amount of loss. How does that differ from here, Grant Thornton would draft a final capital working statement?
I think the biggest point would be that whether that statement could be challenged. And under the arbitration rules, it's virtually impossible to overturn an arbitrator's decision, even if it's wrong on the law. Even if it's factually correct, you can get 10 experts line up and say, this is just absolutely incorrect. You're stuck with it. And I think under an expert determination, that's not the same. And I think Chapman makes clear that even whatever similarities there may be between an appraisal and a arbitration, all of the appraisal rules are not engrafted onto appraisal. And that same standard ought to apply in the context of a different auditor determination, such as, a different expert determination, such as one by an auditor.
Obviously, what we all care about most is the language in the agreement.
Yes, Your Honor.
I think we all agree it doesn't have to say arbitration. There's no magic words. But where is the language that you would rely upon for your position that Grant Thornton's statement is later challengeable? Is there some language in the...
Section 8.10B says all claims can be brought in this court, or not this court, actually, it would be the Superior Court, but then to here. Another grounds cited in SAP that says when you have basically a litigation provision, and when you have a different provision, especially when that provision is unclear or ambiguous, it's indicia that it's an expert determination, not a arbitration. And here, all claims can be brought in state court. So I would say that that's the language in the contract that gives at least plausible grounds to argue that the third-party determination may not be final. But again, the point that brought us here today is a motion to compel arbitration, and not a motion for specific performance or anything like that. It was not raised. They didn't answer. They didn't plead any counterclaims. It was strictly whether this was an arbitration or not. The Superior Court found it not to be one.
What do you make of Section 7.10? Which is the exclusive remedies section where there's a carve-out for 2.06.
Okay.
Does that hurt your position, help your position? Why?
Section 7.
I assume it helps your position, but.
Well, I think it's a nuanced answer, to use my counterpart's language. 7.06 refers not only to 2.06, but it refers to 8.12. 7.06, the heading says exclusive remedies, but I think it's section 8. There's another section toward the end that says headings are for convenience only and shall not affect the determination of the agreement. A couple other points about 7.06. or I'm sorry, 7.10. And before getting there, I would mention that the third-party auditor provisions in 2.06 specifically use the term review, which is a term of art under Arizona statute when it comes to auditors. And that is, and it's not an arbitration, it's a attestation procedure, which Grant Thornton said it wouldn't do. But I'm sorry, back to 7.10. So it's subject to 2.06, subject to 8.12. 8.12 provides for specific performance as well as any other remedies at law or in equity. Well, if section 7.10 and the headings aren't binding, refers us to 8.12, which reserves all rights and remedies at law or in equity, that certainly doesn't hurt my client's position that this is a expert determination. Subject to 2.06, okay, if we had to go back to Grant Thornton, and if Grant Thornton had expressed a willingness to agree to what my clients had intended, at least what they thought this agreement meant, we may have been at Grant Thornton. But when they decided, when they treated it as sort of an arbitration or quasi-arbitration where they were going to simply determine the dispute and under what standards. If they won't refer to GAAP, I mean, that's one of the indicia of a
When you say they treated it like that, who do you mean, Grant Thornton?
Grant Thornton.
So are you saying Grant Thornton viewed it as an arbitration provision?
Their initial draft, I think, it referred to it as an arbitration. Subsequently, I think they plucked that language out in a revised draft. We've never had an agreement with them. We did exchange drafts and things of that nature. But my clients, upon that, in that process, asked them, agree to follow the APA, the Asset Purchase Agreement. They responded by saying, Grant Thornton responded by saying, we'll be guided by the APA. I'm not sure that's the same thing. I think it's not the same thing. Following something and being guided by it are two different things. And moreover, they wouldn't put the reference to GAAP anywhere in their engagement letter. I mean, that's not the deal my clients agreed to. We've had, my clients put in declarations at the lower court. They're in the record. The opposing counsel didn't put or opposing side didn't put any declarations to support their position. And the other thing about 7.10, it's got carve-outs for fraud. It's got carve-outs for specific performance, other legal equitable rights. It's got carve-outs for indemnification, all things my clients sought in this lawsuit. Again, looking at the SAP case, where contractual procedure calls for technical expertise in accounting, it weighs in favor of an expert determination, not an arbitration. Section 2.06 does not refer to the third-party auditor as an arbitrator, a judge, an adjudicator, or anything of the sort. It uses the term review, not arbitration, adjudication, or anything of the sort. The parties did not use the expression conclusive or binding in Section 2.06. Many cases in the briefing will show you, in order for it to be an arbitration, even outside of the jurisdiction, it would say final and conclusive. Those are not synonyms. Or final and binding, again, not synonyms. You can have a final determination by an expert. In other words, the expert's not going to change its report without it being binding on the parties and on the court in future litigation.
Thank you.
I'm out of
Thank you,
time, Your Honor.
counsel.
Thank you very much.
Rebuttal.
This will be the lightning round, Your Honor, given a minute 24. SAP is a perfect example of why this doesn't make any difference, why this discussion of expert determination is a red herring, because Arizona law has never followed that law. Delaware clearly does. Look at Penton, it explains it. But here's what SAP says, right? What happened in SAP was the court referred the entirety of the dispute to the third-party auditor. They decided everything, including good faith, bad faith, you name it. What the court noted is, although the calculation of IAS's EBITDA becomes final and binding after the expert completes its accounting analysis, the authority to resolve the parties' legal questions, like whether IAS violated the duty of good faith, remains with the courts. Because the arbitrator exceeded those bounds, that's why that case came out the way it did. Even in jurisdictions where expert determinations are valid, they're binding, they're enforceable, and you can compel them. So it makes no difference in this instance. And as far as the semantic arguments, Your Honor's already pointed out, I don't believe Meineke has the final binding language. You just, by definition, this is the way it is. Finally, for review, review is an attestation service. You can't review both things if you're deciding between the two of them. That's a red herring. It means what it means in English. Your Honor, thank you.
Thank you, counsel, and thank you both for your helpful argument. We will take it under advisement, have a decision issued in due course, and we will take a recess to let the parties get ready for the next argument.
Thank you, Your Honor.